Hello and welcome everyone. I welcome you all to the second class of this Key Concepts in Indian Polity series. In this series, I'm trying to cover some of the most important and relevant topics in Indian polity from both prelims and the mains examination point of view. The first class or the first lecture that we had was on the different types of majorities. Simple majority, absolute, effective, special, where are they used? If you have still not watched that, please go and watch that as well. In the second lecture, I will be talking today about the different types of writs that we have. Now, a question based on writs is an extremely common question in both the prelims and the mains examination. If you have read Indian polity, more specifically if you have read Supreme Court and High Courts, I am very sure that you would have come across the term writ. If not, no worries, let's start from the very beginning. Writs are orders issued by the Supreme Court or the High Court in case of violation of your fundamental right. Now, you all know in Part 3 of the Indian Constitution, the fundamental rights that have been given to us, amongst those fundamental rights, the most important one, as per Dr. B.R. Ambedkar himself, was actually Article number 32 of the Indian Constitution. The reason why Article 32 is the most important is because it gives you the right to constitutional remedies. In other words, if your fundamental rights are violated, what option do you have? In case your fundamental rights are violated, you as an individual have the right to approach either the Supreme Court or the High Court. You can approach the Supreme Court directly as well, that is your choice, but you cannot be forced to do that. You can also approach the High Court if you wish to. In any of these cases, when you go to Supreme Court or the High Court, the court will take cognizance of the matter and they will issue orders to restore your fundamental rights. Those orders specifically are called as writs. Now, please understand, and I hope all of you have already read this, both Supreme Court and High Court can issue writs. High Court can issue writs under the powers given to it in Article number 226 of the Indian Constitution. So while Article 226 empowers the High Court to issue the writ, Article number 32 empowers the Supreme Court of India to issue the writs. Now, there are some differences in the writ issuing power of the Supreme Court and the High Courts, and I will discuss that also in a lot of detail. But do remember, both of these courts issue 5 types of writs. So there are 5 writs that are recognized in the Indian legal system. What are those 5 writs? This is important for the examination. These are those 5 writs. First, Habeas Corpus, then Mandamus, then Prohibition, then Certiorari, and the fifth one being Quo Warranto. These are the 5 writs that you must remember how they are used, why they are used, who can issue them. So let's start with the first one, that is Habeas Corpus. Now, most of the legal terms that you see, not just in India but around the world, have Latin origin. That is why the phrases that are used in the legal system may not be very familiar to you. Habeas corpus being one example. I'll give you one more example. You might have heard about something called the locus standi. I'm sure all of you are aware of this. Do tell me in the comment section, by the way, what exactly do we mean by locus standi? And if you have any doubts over that, let me know. I'll make a detailed video on locus standi as well. Anyways, so if a person is detained by the police authorities, even at the time of detention, you still have certain fundamental rights. I would remind you, Article number 22 of the Indian Constitution talks about detention, the rights that you had during detention. Article 22 says that even if you are detained by the police within 24 hours, you have to be first presented before a magistrate. The magistrate will decide whether or not your detention will continue. You have the right to approach the lawyer, you have the right to get to know why are you being arrested. A lot of these rights are given even at the time of detention. However, let's assume for a moment, police arrested you but did not take you to the magistrate. They are not letting anyone meet you. They are not even telling you why are you being arrested. This is a violation of your fundamental right. This is where the Supreme Court or the High Court will issue a writ called Habeas Corpus. Habeas Corpus translates into we shall have the body. That doesn't really mean they're asking for your dead body, but They are demanding the authorities to clarify why have you been arrested. The authorities have to tell on what grounds were you arrested, why is it that you are not being given the right to meet the lawyer, or you're not being given the right that is guaranteed to you under Part 3 of the Indian Constitution. This is what habeas corpus is. Now, when Indira Gandhi government had imposed emergency, one of the biggest debates in emergency era was, can all the fundamental rights be curtailed or not? This is where the Supreme Court, in fact, had said that during our national emergency, even habeas corpus can get suspended. That means the police are given a right to arrest anyone randomly. This is something that has been debated long after that as well. As of now, the courts are extremely strict about habeas corpus. Also, please understand, when the court issues habeas corpus, that does not mean that the police necessarily has to leave you. It just means the police or the authorities have to clarify why you are being arrested. They have to make sure that you get all the rights. It's not that they have to release you. They just have to tell the court why are you being arrested. Second, mandamus. Mandamus is issued against a public servant, against a government authority, when they are not doing the job that they have to do, a job for which they are getting paid their salary, a job for which they are actually given this particular position. When they are not doing that, mandamus can be issued. Let's say you go to the State Bank of India, you want to get a draft issued, you fulfilled all the paperwork, you gave them all the details, even then they are not giving you the draft. So in that case, against them, mandamus can be issued. Now, a few things to understand. Number one, mandamus cannot be issued against private individuals or private authorities. It is only when you are working for the state, it can be issued. Secondly, even amongst the government, mandamus cannot be issued against the president or the governor. This is an important distinction that you must remember. President or the governor are not subjected to mandamus. Do remember this. And it cannot be issued against private individuals as well. It can only be issued against the public authorities, and amongst them, president and governor do not count. Now, the third and the fourth writ, prohibition and certiorari, are quite similar to each other. Both prohibition and certiorari are used by the higher court to order the lower court in case a lower court is hearing a matter which is beyond its jurisdiction. When High Court or the Supreme Court believe that the lower court is hearing a matter which they are not supposed to hear for whatever reason, in that case, prohibition or certiorari will be issued. Now, what is the difference between the two? Prohibition. This is used when the final order has not been given. That is, the final order is still pending. You have not been given the final order. This is when the court, that is the lower court, is told to pause, transfer the case to the appropriate court so that they can take it forward. This is the idea of prohibition. It can only be issued against judicial or quasi-judicial bodies and not against administrative or legislative bodies. Means the court cannot issue it against the parliament. Now understand this. This is why when the parliament passes a law, the court can strike down the law after the law has been made by saying that it is unconstitutional. But the court cannot stop the parliament when the law is being made. Please understand the difference. In the process of making the law, the court cannot stop them because prohibition cannot be issued against legislative authorities. The laws can be struck down later on, but within the process, the judiciary cannot make the legislature stop from doing its function. That is how you have to understand this. This is the idea of prohibition. Now, similar to this, as I told you, is certiorari. Certiorari again is issued by the higher court against the lower court with one key difference as compared to prohibition. That difference being that in case of certiorari, final order has been passed. It is to quash that final order, and the higher court says that we will hear the matter once again. This is where the certiorari comes in the picture. So higher court orders the lower court to transfer and to quash a decision that has already been taken by the lower court. This is done because there may be a bias in proceedings, there may be lack of jurisdiction, there may be a violation of natural justice. It is very common. Increasingly, you see there are a lot of appeals that are made to the higher court from the decision of the lower court. This is when the higher court can cancel that order, quash that order. This is called as certiorari. It is important to remember the difference between certiorari and prohibition. Prohibition is preventive. It stops the proceedings from going ahead. Certiorari does not stop the proceeding in between. It has to be used only when the final order has already come out. Fifth one is Quo Warranto. Quo Warranto means when a public authority is holding an office that they are not eligible to hold. Let's assume that a certain post can only be held by someone who is below the age of 65 years. Let's say CAG retires at the age of 65. Somehow the CAG continues to be at the post even after 65. Then after against the CAG, the court can issue Quo Warranto. That is, you have to explain what is the authority with which you are still holding this post, because you're not entitled to hold this post anymore. This is why Quo Warranto is issued. Again, this is something that can only be issued if the office concerned here is a public office. The appointment should be legally questionable. It is not issued against a private authority. In all of these cases, all of these writs have multiple cases related to them. If you want these PPTs that I'm using in the lecture, please feel free to join my Telegram channel. I'm giving the link of the Telegram channel in the description of the video. You can join that. I'll be sharing all these PPTs there for your own revision. Now, in the beginning, I told you writs can be issued both by the Supreme Court and the High Court. However, there's a key difference between the two. And this is again important for the examination. Article 32 of the Indian Constitution empowers the Supreme Court to issue these writs. On the other hand, Article 226 empowers the High Court to issue these writs. There is a key difference in between the two that you must remember. For example, if you look at Article number 32, Article 32 says that the Supreme Court can issue the writs only if fundamental rights are violated. In case your other legal rights are violated, Supreme Court will not issue the writ. On the other hand, High Court under Article 226 can issue writs for fundamental right violation and other legal rights as well. Now, a lot of aspirants mistakenly ask this question, that doesn't mean the High Court has more powers. You're allowing the High Court to issue writs on all other matters as well. Does it mean the High Court has more powers? Not really. Imagine this. In a company, the boss, the director, the people sitting at the top, they don't look into day-to-day issues. If someone is absent in the company, out of the thousands of people that are present in the company, one of them or one of the employees is absent today, the director, the chairman is not told that he is absent now, what do we do? That small decision, small problem is looked into by the lower people at the lower level of the hierarchy. At the higher level, you don't disturb them with these small little matters. That doesn't mean that the lower manager has more powers, chairman has lesser powers. That's not how it works. Similarly, in this case, the Supreme Court only issues the writs for fundamental rights violations, not other. That does not mean it is less powerful than the High Court. It just means that we need to maintain exclusivity for the Supreme Court. Also, Supreme Court can issue the writs across the entire country, while High Courts can only issue the writ again in their jurisdiction. That can be in one state, that can be in multiple states. For example, in case of the Bombay High Court, it looks into multiple states, Bombay, Maharashtra, Goa, etc. This is the difference between the two. Also, for High Courts, it is under Article 226 that they have the power to issue the writs. Article 226 in itself is not a fundamental right. Article 32, on the other hand, under which the Supreme Court issues the writs, is in itself a fundamental right. These are certain key differences between the two. This entire topic of writs is extremely relevant and important for the examination. This is it for this particular class. I'll be back soon with class number 3. As always, if you want me to cover any other important concepts in Indian polity, feel free to let me know in the comment section. If you want this particular PPT for your own revision, feel free to join the Telegram channel. I'm giving the link in the description of the video. If you're new here, do hit the like and the subscribe button. Thank you so much. I'll see you in the next one. Bye-bye. Jai Hind.